record reflect that all our jurors are in their seats. Everybody has their pass. If you don't have your pass, raise your hand. No hands are ready. The state having rested will be evidence for the defense.
Defense rests on the Constitution of the United States, Your Honor.
Thank you, Mr. Charnes. Members of the jury, all of the evidence has now been presented. It will soon be your duty to decide from the evidence what the facts are and to apply the law that I'm about to give you to the facts in arriving at your verdict in this case. Prior to the summations of the lawyers and final instructions of the court as to the law that you will follow, I'm required to confer with the lawyers about a matter of law involved in this case. For this purpose, you will now be excused back to the jury deliberation room for approximately 5 minutes, after which we will proceed with the conclusion of the case. Do not yet let your minds be made up about this case, because you have not yet heard the final summations of the attorneys or the instructions on the law given by the court. Again, I caution you not to discuss the case with each other or anyone else, or permit anyone to discuss it in your presence, or speak to anyone involved with this case, and you will remember our previous admonitions. So, at this time, if you would you pass where you are, step into the jury room. You have back about 5. Of the jury, Mr. Charnes.
Yes, Your Honor. The accused renews his motion to dismiss each and every charge due to the insufficiency of evidence of every element of every charge. In addition, mentioning the double jeopardy and the same charge issue that we discussed yesterday. The argument's no different. We've heard it before. And to renew the motion to dismiss on constitutional speedy trial grounds. It's very similar to the argument, almost identical to the argument that was made back in March whenever that motion to continue was made. Again, the stated reason for the continuance back then was Dustin Porte's lawyer wasn't available, and he apparently was at that time going to be a witness, and waiting for the DNA evidence. And as I've argued, the DNA evidence was collected as to my client back December of 2012, and the forecast was that with a rush order it would be done. I put that in writing, and attached to that is the other motion that is not to be heard now. I don't have any further argument. That states my position, and just to renew the speedy trial aspect, and I cite the cases, the federal case, about how he's been punished differently than other folks who might simply be in the Durham County Jail. So day for day, his sentence has increased as these cases and as Mr. Donovan's research after has shown. But I'll sit down. I've made those arguments before just to bring it to Your Honor's attention. Could I retrieve my file stamp copy of those? I had handed up originals. The motion to dismiss and the affidavit, there was originals and then two of our copies, so I could get them file stamped, just so I don't lose track of them. So the originals would be the bad signatures with the Sharpie and
the ones that you filed today?
Yes, Your Honor.
Oh, I see.
May I approach?
Yes, are these his copies, or you got the originals? Yes, sir. Here we go. Thank you. All right, those motions to dismiss are denied. Any other matters for the jury?
No, Your Honor, for the defense?
Nothing for the state.
Everybody ready for the closing summary?
Yes, Your Honor.
Thank you, and as you, Ms. Strong?
Your Honor, I would have one request for the state, and that would be that we be able to use a lectern, and I don't see one in the courtroom.
Where do we have, is the lectern back here in the, can we get that? Do you, you're not bound by it, but, do each of you have any, I'm just kind of trying to get an estimate of the day's proceedings. Do you, have any estimate about the length of your summations? Mr. Charnes has 2, state has 1. Do you have any?
Yes, Your Honor, I think the first would be fairly short, 20 to 30 minutes, and then the second one depends what they say, which might expand.
State have any,
Your Honor, I don't anticipate taking more than an hour, maybe less.
well, it may be that we get both of those done before the 1 o'clock lunch recess is the reason I was looking at it. And that's, we'll get that lectern in just a moment. But I think we'll go ahead. Let's see what.
Your Honor, may I inquire about this replica orange to demonstrate, it may not be the first argument, maybe the second. I don't want to handle a firearm. I don't want to disarm one of these officers.
State, you heard on that? You
No,
know,
Your Honor.
I think it's clear to everyone that it's not the gun. But you're using it for a demonstration purpose.
Yes, Your Honor.
To demonstrate not as a kind of evidence, but to show what one of the officers, or the officer might say.
What did or did not happen?
What did or did not. So that is without objection.
Thank you.
Mr. Charnes, did you want the lectern up there, or do you want to move to the side for your?
For myself, I prefer to have it over here. Can I move it where I'd like it?
It's your argument, so you're going to get to have it set up the way you like it to be set up. And then we'll take a brief pause. There we go. All righty then, let's bring the jury back in. All right, let the record reflect all our jurors go back in their seats. Ladies and gentlemen, all of the evidence has been presented. It's now time for the final summations of the lawyers. At the conclusion of these summations, I will instruct you on the law in this case, and then you will be taken to the jury room to begin your deliberations. Final summations of the lawyers are not evidence, but are given to assist you in evaluating the evidence. The lawyers are permitted in their final summations to argue, to characterize the evidence, and to attempt to persuade you to a particular verdict. It is improper for a lawyer in a final summation to become abusive, to inject personal experiences, to express a personal belief as to the truth or falsity of the evidence, or to make arguments on the basis of matters outside the record, except outside the record in this case. A lawyer may, however, on the basis of the lawyer's analysis of the evidence, argue any position or conclusion with respect to a matter at issue. Now, if in the course of making a final summation, a lawyer attempts to restate a portion of the evidence, and your recollection of the evidence differs from that of the lawyer, you are, in recalling and remembering the evidence, to be guided exclusively by your own recollection of the evidence. The way the procedure is in this matter, Mr. Charles has the opportunity to address the jury first in an opening summation, and the state will have an opportunity to make its summation, and then Mr. Charles will be given an opportunity to make closing summation. Mr. Charles.
Thank you, Your Honor. May it please the Constitution, jury, counsel, Mr. Riley. Whatever your verdict today, whatever you do, if you found my client guilty or not guilty, you will likely remember what you did for the rest of your days. It's not something you're going to take lightly. It's not something the court takes lightly or anyone else in this courtroom. It's something you will not forget, and that you will be careful, and that you will follow the law. And you made assurances to all of us about having the back of the Constitution, and we asked each one of you whether you could do that, and you answered affirmatively. And so now, this is the time that a lot of times lawyers offer thanks for how long it's been. What you're doing is something that's important to a constitutional democracy. And as the court instructed you early on, that other than military service, what you're doing is one of the things that keeps us a free people. So I would thank you on behalf of the Constitution and my client and myself. And this is how it should be, that you take seriously this awesome responsibility. When a young man is facing literally decades in prison, depending on how things go, and that under our system, you are the judges of the facts. The judge will provide the law to you. So in some sense, when you heard the lightning and the thunder, and we kind of joked around about it, it's a clear day to day. But in some respects, you're like the Olympians. You are the gods with a small g of the facts in this case. You determine what it is. What I say, what these folks say, are simply argument or summation. You have to recall, all 12 of you, your 12 brains and your ears and your smells and everything you saw in this courtroom are much more powerful than any single lawyer, 2 lawyers, a whole bevy of lawyers. There's 12 of you, and there's a power in that. So I want to start off leaving you with 3 words. I'll come back to it. Shall game cover up railroad train? And I'll come back. I'm not going to ask you those words, but I'm going to come back to that. So here is an empty chair. It's a witness chair over there. Folks either swore or affirmed on the Bible. Well, what this represents is all the evidence that was not presented. Folks that could have gotten up here, folks that could have made that little walk, those number of steps from back here out into the hallway. Not very far to go from the hallway where these folks are up to the witness stand, and there were 93, over 93 witnesses that were listed. And all of you heard those names to make sure you didn't know any of them. Well, the bulk of those folks never hit the stand. And there's some important ones. And I'll get to that in a moment. But I want to talk to you about reasonable doubt. The burden of proof. As I said in a lighthearted manner during jury selection, I could sit there and twiddle my thumbs. I could be one of those folks sitting here, be a potted plant lawyer, and just watch and see what happens. And of course, I didn't do that because the Sixth Amendment to the Constitution requires zealous representation. But he didn't pick me, so don't blame him, blame me. If you want to blame anyone for something that went wrong, or I offended someone, or I was rude, or I wasn't as polite as I should have been, or I wasn't even funny, or I wear bad suits, that's my problem, it's not his problem. But the burden of proof is always over here, always. And the judge will instruct you, the defendant, the accused, has entered a plea of not guilty. The fact that he has been charged is no evidence of guilt. Under our system of justice, when an accused pleads not guilty, he's not required to prove his innocence. He's presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is based on reason and common sense, arising out of some or all of the evidence that has been presented, or lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies you or entirely convinces you of the defendant's guilt. And the judge is going to give you an instruction about interested witnesses. You may find that a witness is interested in the outcome of this trial. You may take the witness's interest into account in deciding whether to believe the witness. If you believe the testimony of the witness in whole or in part, you should treat what you believe the same as any other believable evidence. Interested witnesses. Now, who did we have as witnesses? We had a lot of folks in blue. We had CSIs. Are they interested witnesses? Do they have someone's back? How did they testify? Use your common sense. Use your everyday common sense. The judge will instruct you, and that's exactly right. When the question is asked by the prosecution and the testimony comes easily, and there's that nice rapport, but when on cross-examination a very simple question is asked, and there's a struggle to get out the answer, use your common sense. Is that person an interested witness? And there were some heroes in blue that got up on that stand, and they testified to what they know to be true, let the chips fall where they may be. That's tough in a case like this. An officer received a gunshot wound to his thigh. Can you imagine a situation where folks in blue are more upset? You can't. It's understandable, they're a family. And for most reasons, that's a very, very good thing. But it's not so good when someone puts their hand on the Bible or affirms and won't answer one side's question. That's a problem. That's not family. We have a Constitution, and it requires us to do right when we get up on that stand. So I'd ask you to consider the witness's testimony, whether they're interested, based on the way they answered questions, whether they appeared to be forthcoming. And some of them were very forthcoming, and I believe they were heroes. So, if you don't know, you have to say no. You have to say not guilty. So, based on proof beyond a reasonable doubt, if you say, that's not guilty. If they haven't proven their case, that's not guilty. It's a hard thing. You might be guilty. That's not good enough. Not in our system of government. Not in this courtroom. So the reasonable doubts, lawyers like, oh, there's so many reasonable doubts, you have to find them not guilty. What is a reasonable doubt? It's something that you are not entirely convinced of. So it could be a lack of something, and that's why I have this witness chair, and you think about all the things you wanted to know that you didn't know that are piling up. And let me talk about a couple of them. What did the prosecution offer, and what didn't they offer? What things did you see, what things did you not see? The prosecutor has a duty under our law to seek justice, not simply to convict. And you are the judges of the facts. So what did they do? What did they offer? What did they not offer? Some people use this phrase, talk to the hand. In this case, it's not talk to the hand, it's a look at the hand. That they didn't give you a photograph. Investigator Corporal McMaster talked about all these photographs that were taken of the whole body, because he's a homicide detective at other times, and he knows it's real important that depending on where someone's hands are, they're going to be burned. There's going to be marks. And he said on the stand, I recall him saying, this man didn't have marks on his hands. And you recall the demonstration right in front of you? The prosecutor was there demonstrating, acting in the place they claimed of my client. And where the hands were, the officer claimed his right trigger finger was up. Then you notice where his other hand was? He was in a pretty dangerous spot, whether he was dealing with someone else or not. But what they claimed, what their evidence was that my client had his hands in a place that anyone that knows anything about guns, and some of you know a whole lot about guns, would have received burns. Wouldn't you want to see those pictures? Wouldn't you want to see those pictures? Let's put that something right here. The witness that could have testified, that didn't walk from over there up to there, that short little journey, that could have sat here, CSI, and showed you a picture of his hands. Nothing. They didn't do it. That's their burden. Why did they not do that? Why? It's a reasonable doubt. That alone is a reason on the assault charges to find my client not guilty. That fact alone, and it's uncontroverted. Why? Why would they not show you a picture? Not guilty. Based on that alone. And the finger on the trigger, again, that goes along with that. Use your common sense. Someone get back, I'm going to shoot you, I'm going to shoot you. Where's their finger? If that creates a concern for you, that's a not guilty. But you have the lack of burning, the lack of evidence, the lack. Not guilty, not guilty, not guilty. It's their burden. It's their burden. They didn't meet it. The lack of injuries to Officer Stewart's face. As you recall his testimony, the brutal beating, blow for blow. So what little evidence they did put in, let's talk about that. We had, I believe John Franklin testified, State's Exhibit 13. And the testimony was, he looked at his airway. So he's looking at his face. There's no broken teeth. There's no bloody lip. There's no contusion. His eyes are fine. Because he had to look there. If he was bleeding, of course he would note that. And he wasn't. So you can look at this exhibit and look at page 5 of 6. And they talk about the injury received from the gunshot wound, but no other wounds noted. And further down, secondary assessment, so they assessed him again, revealed no injuries or abnormalities. So as far as, where are the pictures that they took in this serious matter to everyone in this courtroom, but particularly to the police department and to my client. So let's put this along with a number of other evidence. Where's the gunshot? Where's the photographer? Where's the crime scene investigator? Where is the medical doctor? Nurse, technician. We had someone that works in the office that knows about the records. Where's the doctor? They weren't there. That's their burden. Why would you not call a surgeon or a doctor or even a nurse in a case like this? Shell game. Keep away. I got something that I don't want to show you. It's not my burden, it's their burden. Their burden. So if you don't get the doctor and you don't have photographs, when you want to see the entrance wound, the gunshot, the photograph was, the whole body was photographed. Don't you want to see, was the entry wound angular? Or was it up and down? Was there other markings from distance? Where's the expert? Where's the expert about the gunshot residue? Was there gunshot residue in the wound? Not a thing. No one from over here, no one made that little trip to that witness stand to say it. So let's start to get a little higher. The things they didn't do. Their burden, reasonable doubts. So go through the witness list, and we have folks on here, officers. We have evidence techs, folks that weren't called, other folks from EMS. We have FBI agents, Mike Sutton, SBI agent, PA Stevens, another SBI agent, Richard Dean Amatuli, SBI, Laura Gillespie, ATF. All these folks, you heard the names back, it's going on 3 weeks, but you heard the names as potential witnesses. And folks don't have to call all their witnesses, but when they don't even put a surgeon up or an expert about gunshot residue. Where's the lab test on gunshot residue? This gentleman wanted to talk about it, but he's not the lab, the state lab in Raleigh. And what about Miss Coble, Marilyn Coble, that was going to Duke Hospital to talk to Officer Stewart? The form for gunshot residue, what does that form say about what he was doing? You don't know. It's their burden. Put that on the pile. Marilyn Coble, what was she told? Because that form was sent with the gunshot residue testing. My client and this officer sent to Raleigh, comes back. Where's the witness? What's on that form? Does that form say the officer shot himself in the leg? You don't know. But it's their burden, and they didn't put it on, and you can decide that that's a reasonable doubt. No forensics, no DNA, no fingerprints. That wastebasket that had a badge and some cuffs, that was found a day and a half later. And there's all those maps, and I don't need to show you those maps, but there's large swaths of Durham that were searched with dogs and people doing exercises. But how then, a day later, is that stuff going to show up? And was there gunshot residue in any of that stuff? That it was with the gun, and the gun was taken out? State's Exhibit 7. Why wouldn't you test that? How did that happen? They said the maintenance man, they did a exclusion swab for DNA. What happened to that? I don't know. It's the witness that isn't sitting here, never went there, that didn't make the little trip from out in the hallway. Why? 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 Reasonable doubt, reasonable doubt, reasonable doubt. Did they analyze the officer's cell phones? You saw some text messages. Client's brother, Darius Riley, about what he ought to do so he's not shot to death. And you don't see those because they want you to see that. But in there, that's consistent with my client and outside his mom's house that same day, that same afternoon, saying, I'm the guy you're looking for. I'm the guy you're looking for. Which is kind of similar to what the testimony of Officer Stewart is when he said my client disarmed him. He said, I can't believe you tried to shoot me. He didn't curse. He didn't curse. He was perfectly polite. Man, can't believe you tried to shoot me. And later, I'm the guy you're looking for. So you can consider whether he was on his way to turn himself in to the Durham Police Department, and when they talk about the shot, how many guns were facing him, and this massive manhunt, and here he says they didn't know, one officer didn't know who he was. I'm the guy you're looking for, I'm Carlos Riley. All part of your reasonable doubts. But the officer's phone. So let's look at his phone. What about the officer's phone? What was he doing that morning in this high drug crime area? What was he doing? Well, we have a little bit of evidence of what he was doing. We have the guest list, State's Exhibit 40A, and it's conveniently date and time stamped 12/18/2012, 9:54 a.m. and 19 seconds. And there's 3 plates on here, 3. And one of them is his daddy's plate for the car that's a manual drive, a stick shift, that was on an incline. That the officer felt so at ease with this gentleman that he left that car on. You heard some testimony of other folks. What would they do? And then common sense. If you're worried about someone reaching for something, if you're not totally convinced this man is unarmed, and he knew he was unarmed, because he pressed him, that something else is going on here. What is going on? What happened in this time after he got on to work and he was going off the books and he's writing things down on a little piece of paper that's in the SUV that you never saw the inside of, the radio in there, to call into communications in keeping with the general orders of the police department and common sense and his own safety and the safety of all. Why is he operating off the books? Why is he doing that? To give a verbal warning for spinning of tires in a high drug area with a young, light-skinned black male leaning in the car? I remember if he said, I remember if I asked about drugs. He's a drug interdiction officer. He's trained. He's trained. And we have a picture. The member of the crime scene investigator was very proud of this picture. So could he see into that car? Could he see the race? Mr. Riley, he noted the race of the guy outside, and he said it made him curious. Well, what made him curious in this high drug area? So if he's curious, and it's a high drug area, makes sense. He's talking about, do you have any drugs? But he didn't remember that. It's not in any of the statements, as I think he testified. You use your recollection. What's going on? If you're going to give a verbal warning and you didn't call it in, if you don't find anything after you search, hey, it's all good. You drive off. Is anyone going to complain that they didn't get a ticket? Won't they just be happy it's over? And then if the officer finds something, they call it in. So his statistics, he never gave me an answer. Is it 76% of African Americans that you stop in the year prior to 12/18/12? So what is it? Is it 80%? Because you do things off the books, and therefore the State Bureau of Investigation never finds out about how many African Americans you stop? And the response may be, well, he's African American. He wouldn't do this to Mr. Riley. It's about power. It's about the gun. It's about what they can do. What did he do? What did he do that day? And there's an instruction about motive. We'll use that towards him. He's doing all of this. Why? Why is he doing it? Why would you operate off the books? So when you evaluate his testimony, consider why he would violate the rules of his department, rules that are for his protection and the protection of the public. Is he doing that because this is what he does? It's up to you, and that's a reasonable doubt. Those mobile data computer messages inside of the SUV, you didn't see any pictures, you didn't see any mobile data computer messages. Aren't those pretty important to know about what's going on, what he was doing? So if there's a mobile data message and one of these witnesses knows about it and they weren't called, that he was going to turn himself in, that would be pretty important to know. But the way the prosecution handled this case, you're not going to know it because they put in evidence to justify their theory of the case. They don't put everything in. So that picture of the car, you got another one of the plate. So you got the outside, and you can see its bucket seats. And I'll walk with State's Exhibit 16. So inside of this very clear window, you can see the bucket seats. But where's the picture of the inside? The handbrake. How big is that handbrake? Is it a tiny little one? Is it a big one? And then you have other pictures. Here's of the round in the back. And you can see a little bit of the seat. And this is State's Exhibit 45. And there's one other, but where's the picture? Where's the pictures inside showing the bucket seats? Because if he's in the passenger seat on his back, and there's a giant brake, handbrake, how is that even possible? How is it possible that he's on his back in the passenger seat? Where's the picture? Reasonable doubt. Their problem, their lack of proof. Not guilty. Hands, gunshot residue, lack of experts, reasonable doubts. Not fanciful doubts. Real doubt. Reasonable doubt. And I was going to say there's no videotape in this case. There's no in-car camera. Let's watch it now. It's not there. There's no body camera. It's not there. But we have Ms. Hikes, or Hikes. In a sense, she's a videotape. She's a human that recorded what happened after the pop. Boom, she goes to the window. She's got a statement. She made 3 statements, 2 of which are in evidence. The state put them in, 11 and 12. And what is clear from her statements is that Mr. Riley had the gun in the air, pointing to the sky. The officer was where? In the driver's seat. Not in the passenger seat. Pop, she looks out the window. Here, Mr. Riley's here, guns in the air. Pointed towards the sky. So how does one get in the course of a second from the passenger seat on his back with him on to the sitting? It's not possible. Those 2 things are not possible. She waited. She thought about this. She knew it was important. She told you she knew it was important. And I would contend she's no great fan of my client. She had no particular reason to say things to help him, but she was someone that got up there and wrote down twice, both of these, you can see 11 and 12, the date is 12/18/12, that same day. And she gave a statement that was recorded. And that 911 call, or the call to communications that didn't happen, instead we got a little piece of paper, wouldn't it really help you decide what was going on if that officer had called it in and told you the reason? So even the careless and reckless driving is at issue, and there's a reasonable doubt, because he didn't call it in. So you got the passenger seat versus the driver's seat. You have testimony that my client was on top of him in the passenger seat. How that even is possible considering what happened earlier, or a version another time that my client was outside and then Miss Hype saw him outside. The chain was outside. The badge and the cuffs, according to the testimony of Officer Stewart, if you recall, if I'm recalling this incorrectly, fell to the floor of the car. So all those are reasonable doubts about, serious reasonable doubts about what happened, enough to find my client not guilty of these charges. Did Officer Stewart file a workers' comp claim for an accident? They didn't present any evidence of that. So that goes on the pile. Is that something he did and claimed it was an accident? Reasonable doubt. Reasonable doubt. Not guilty. Their burden, not ours. Literally, you could go through and stand here and go through hundreds of reasonable doubts in this case that arise from the lack of evidence that they've presented, the evidence they've presented, the things they did, the things they didn't do. And the prosecutor mentioned in her opening that this is about choices. Of course it's about choices. We all make choices. We make good choices, we make bad choices. They made choices about what to show you and what not to show you. The officer made choices to violate his general orders, state law about how you record this. 2.5 years later, there's still not a record of what happened in this case that's required by law. And he's been sitting here. You can do that by hand it to someone else and fill it out. State law requires it. His figures on stops of African Americans are 1 African American short. And there's no one in here that is making him follow state law. So that gives you an indication about what's going on here. Again, interested witnesses, what is this really about? He made a choice to operate in the netherworld, in this world that he has all the power, he has all the control, and on that day he wasn't in uniform. He didn't have that uniform on. He was in plain clothes. And I'll talk to you later about what someone like my client might have in their mind when someone in plain clothes in an SUV who's not acting the way he should be acting gets you out and is going through your pockets, on a squealing the tires because you were talking to an African American at the window. The prosecution is likely, during their case, and I don't know what they're going to do, they don't share their secrets with me, to play the 911 call where the Officer Stewart did call this in. He called after the gunshot wound. And I would ask you to carefully listen to that call. What did he say? What does he not say? And ask you, when they play that, to think, is the pain and agony any different if an officer shoots himself in the thigh than if it happens some other way? Are the cries of pain and the agony any different when one shoots himself? So I'll get to speak to you again after the prosecution makes their argument. And I'll ask you at that time to find my client, Carlos Antonio Riley, not guilty on each and every charge, because the state of North Carolina has not proven each element of each offense beyond a reasonable doubt. For the reasons, the witnesses who didn't testify, the witnesses who did testify, and you just discern their demeanor. For all those reasons and all the reasons you think of, there's 12 lines, good lines, both sides. Both sides all agree you folks are the jury. You are the decider of the facts. And we ask you to find my client not guilty. Thank you.
Thank you, Mr. Shaw. Jurors of the state.
Thank you, Your Honor, if I can have this get set up.